are the parents of Ethan Crumbley, is that correct?
Yes, correct.
That is correct.
Thank you. If you could just state your full names, that would be great.
I'm Jennifer Crumbley.
James Crumbley.
Thank you very much.
Welcome back. Those are the parents of the suspected Michigan school shooter in a Zoom hearing yesterday. You know, the most dramatic moment in a courtroom, of course, is at the end of a trial when a verdict is read. Another one is at the very beginning, after a horrible crime has been committed, and for the first time, the suspect appears in court. And that is exactly what played out yesterday in Oxford, Michigan, after the heartbreaking school shooting that claimed 4 young lives. The suspect, 15-year-old Ethan Crumbley, we'll say his name once and that's it, has been charged as an adult with terrorism causing death and 4 counts of first-degree murder, along with several other charges. The community there, of course, is still in shock, grieving the loss of the student victims. Police say they have evidence showing that the suspect had a premeditated plan to carry out the shooting at that school. The suspect appeared before the court yesterday in the Zoom hearing. Here's how it all played out.
Sir, do you understand all the charges against you?
Yes, I do.
Again, you have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand your right to remain silent?
Yes.
You also have, of course, your right to an attorney, and Mr. Kozak and Ms. Hatton have been with you, and that right will continue throughout all legal proceedings. And as it relates to anything further, we do need to set a bond. As it relates to bond, I will first let actually we do have pretrial services here to make a recommendation as to bond, and then we will let each attorney speak as it relates to that. So if the individual from pretrial services can come forward, state their full name and spell it for our court recorder.
Darla Finley, pretrial services.
I'm sorry, Judge. Just before we do that, I just want to make sure it's clear that my client is standing mute. We're asking the court attention or not guilty.
I'm sorry. Yes. I will enter a plea of not guilty on his behalf, and we will set this for bond. Thank you, Mr. Kozak.
Darla Finley, pretrial services. Darla Finley. The defendant was unable to be interviewed due to his location at the Children's Village. Therefore, that we have limited information. We do know that he's 15 years old, a resident of Oxford. He's a sophomore at Oxford High School. He has no prior juvenile record, no noted police contacts in Clemmis. Given the serious nature of the matter, there's no conditions or combinations of conditions which will assure the defendant's appearance in court or safety to the community at large. Therefore, we recommend that bond be denied.
Thank you from pretrial services. Mr. Keast, anything you'd like to state?
I would, Judge. Thank you. Because the defendant is a juvenile charged as an adult, this court must look at Michigan Court Rule 6.909, subparagraph 2. That court rule states that regarding detention without bail, if the proof is evident or if the presumption is great that the juvenile committed the offense, the magistrate or the court may deny bail, subparagraph A, to a juvenile charged with first-degree murder. Judge, in this case, I am asking this court to deny bail, as pretrial supervision has indicated. As a offer of proof, I think it's appropriate for this court to have a brief chronology of what happened on November the 30th, 2021. As you heard during the swear-to, Judge, Oxford High School is equipped with surveillance video. We've had the opportunity to review that surveillance video just this morning. And what's depicted on that video, honestly, Judge, I don't have the words to describe how horrific that happened on November the 30th. It depicted just before 12:51 p.m., this defendant entering a bathroom with a backpack. A minute or two later, he exited the same bathroom without the backpack, but with a gun in hand. At that point, he methodically and deliberately walked down the hallway, aiming the firearm at students and firing. Right outside the bathroom, he began firing, Judge. After children started running away from the defendant, he continued down the hallway, again at a deliberate and methodical pace, pointing and aiming inside classrooms and at students who hadn't had the opportunity to escape. This continued on for approximately 5 minutes. The defendant went to another bathroom. As deputies arrived, he set the firearm down and he surrendered. Judge, a preliminary review of the defendant's social media accounts, his cell phone, as well as other document evidence recovered on scene show that this defendant planned the shooting. He deliberately brought the handgun that day with the intent to murder as many students as he could. Judge, I believe no bond is appropriate. And again, like I stated, at the appropriate time, I'd like to make a motion to transfer this defendant from Children's Village to the Oakland County Jail.
Thank you. Mr. Kosak?
Your Honor, understanding the extreme nature of this case and understanding the circumstances at hand, and having spoken to Mr. Crumbley as well as his parents, I'm going to leave the setting of the bond and the discretion of the court.
Thank you. Anything further from Ms. Hatton?
Nothing further, Your Honor. I leave in the discretion of the court.
Thank you. And I'm assuming you don't want your client to speak.
That's correct, Your Honor, on both Mr. Kozak and my behalf.
Thank you. I do believe, based upon all the information that's been provided to date, that a no bond, a denial of bond is appropriate pursuant to court rule, and I will order no bond on this case.
I do have a motion for the court. The defendant's currently housed in Children's Village, if I may.
Yes.
Thank you, Judge. Under the same court rule, MCR 6.909, subparagraph B regarding place of confinement. Subparagraph 2. On motion of a prosecuting attorney or superintendent of a juvenile facility in which the juvenile is detained, the magistrate or court may order the juvenile confined in a jail or similar facility designed and used to incarcerate adult prisoners upon a showing that the juvenile's habits or conduct are considered a menace to other juveniles. Judge, in this case, I can't think of a more appropriate set of circumstances for a transfer from Oakland County Children's Village to the Oakland County Jail. Now, this court must also look at the statute, and that's MCL 764.27A. I spoke with Lieutenant Tim Willis, who is the officer in charge, and did the swear to this afternoon. He has confirmed that the Oakland County Jail can house this defendant in a location out of sight and sound from adults, and that's the standard in the statute, Judge. The Oakland County Jail is better equipped to handle this situation. They have done so in the past. They have done so in conformance with the statute. It is a more secure location, and I would ask that this court find that this defendant's conduct is a menace to juveniles by evidence of the simple fact that he targeted juveniles in this offense. Count 1 is a charge of terrorism via murder, Judge, and the evidence that will come out of the preliminary examination and the subsequent trial will show that this was a planned event, it was methodical in its operation, and it was done so to terrorize and intimidate others in the community, Judge. I do believe the Oakland County Jail is the appropriate location to house this defendant. Thank you.
Thank you. As it relates to that issue, Mr. Kosak and Ms. Hatton.
Thank you, Your Honor. All due respect to Mr. Keast, Your Honor, I want to remind the court, and I know the court doesn't need reminding, that these are allegations. He has not been found guilty of these issues or these charges as of yet, and I'm asking the court to. I'm objecting to the transfer at this point in time. I think the Children's Village is more than capable of monitoring him and maintaining the safety of the other residents of that facility. And I think at this point, Judge, if the court's going to consider this motion, I would ask the court to perhaps hold the ruling in abeyance until after the preliminary examination, at which point the court will have had a chance to have taken sworn and heard sworn testimony regarding these incidents.
Regarding the issue itself,
regarding the
the
incident,
fact that he shouldn't be moved?
Regarding the incidents itself, Your Honor, and because I believe that's what the prosecution is using as a reason for the transfer in and of itself. That's evidence of the need to transfer.
Thank you. Ms. Hatton, anything?
Your Honor, just very briefly, this court has already found that the proof is evident under 6.909. And I know this is a preliminary showing. Obviously, defense has not had the opportunity to review discovery. Neither has this court. However, it is alleged in these 24 counts that this defendant didn't commit first-degree murder upon anybody, but he targeted other juveniles. And I believe that 6.909 subparagraph B is written specifically for a situation such as this. The Oakland County Jail is the appropriate location for this individual, Judge. It is, like I said, well equipped for this. They have the ability to keep this defendant separate from both sight and sound of other adults. This is appropriate in these circumstances, Judge.
Ms. Hatton, anything further?
Your Honor, I concur in Mr. Kozak's argument. I will advise the court that as Mr. Ethan Crumbley's juvenile attorney, I did have an opportunity to speak again with Mr. Ethan Crumbley at the juvenile facility, Children's Village, as well as the individuals who are supervising Mr. Crumbley, Ethan Crumbley at Children's Village. It's been reported to me, Your Honor, as an officer of the court, that Ethan has been cooperative. He is on suicide prevention there at Children's Village. He's not in general population. He's secluded and he's receiving one-on-one supervision. I would ask the court, based on that information and that he is cloaked in the veil of innocence unless proven guilty, that he remain at Children's Village until after the preliminary examination. Given that Children's Village is suitable and able to maintain the safety of the other children at Children's Village, I believe it is appropriate at this time that Ethan remain at his current placement with the current conditions and supervisions in place until the preliminary exam, which is in a matter of days, December 20th, 2021, as this court has set.
I'm going to certainly err on the side of caution. I think it is within the court rules to do so. And I would agree with Mr. Keese. This is the perfect example of a case that should be done to protect other juveniles. So I will have him move to that facility. As has been indicated, that he will be in isolation and will not be in contact with any other adult inmates, but only that of sheriff's deputies.
That taking place yesterday. The defendant accused of killing 4 fellow students, injuring 7 others, including 1 teacher. And this morning we are learning from our affiliate WXYZ. There are reports of copycat threats across the Detroit, Michigan area. It's forced the closures of 12 schools today. Those schools shooting threats are popping up on social media, making it an already uneasy situation much worse there in Michigan. Police are investigating. We'll continue to follow